you very much, Jennifer. I'm Christine Johnston, and with me is Matt Surge, and we are municipal attorneys with Drummond Woodson. And we are going to be talking this morning about the process of what the ZBA does. Chris Bolt is going to cover in his session the substantive issues of variance criteria and what a special exception is and all of that. We're going to talk about how you do what it is you need to be doing. We're trying to figure out how to advance the slides. One moment. Okay.
There you
go. All right, so I'm going to start with some preliminary information that's useful to help understand all of the rest of what we're going to talk about today. So the first thing is what the ZBA is for. Most importantly, the ZBA is a safety valve to prevent zoning restrictions from infringing on people's constitutionally protected property rights. Everything in land use is some kind of restriction on how people use their property. And it's a balance really between the constitutional property rights of property owners and the need of society to control the way that people use their property. And it's important that the line isn't crossed between permissible regulation and taking of constitutional property rights. So that's where the ZBA comes in most of the time. It is also a mechanism for additional relief for administrative appeals of certain local decisions, and it has original jurisdiction over things like special exceptions and equitable waivers.
Christine,
Yes.
We're getting some comments that it's kind of hard to hear you guys. I don't know if there's anything. I mean, I can hear you, but the quality isn't that great. But
let's move. Is that better?
Is this better? Can you hear us better?
That's a little bit better for me.
Yeah, our microphone is literally right beneath us.
It's right there.
Can't get any closer.
Yeah, I think it's just a little echoey, just based on where your location is. So.
Okay.
Oh, okay.
But
we'll try to fix that. In the meantime, if I speak a little more slowly, is it easier to hear me?
Yeah.
Okay. We'll try this. Oh, there it is. Okay. So the ZBA is a judicial body, which is important to understand the context in which you are acting. The ZBA is not legislative. It does not create ordinances or regulations, and it doesn't amend them. That's something that the planning board does and the voters usually. It's also not executive. You don't enforce decisions. You just make them. What the ZBA is quasi-judicial. You are somewhat like a court. You interpret the ordinances and regulations in your town or city, and you apply that interpretation to the application or appeal that you have in front of you. And the reason that all of this is important is that someone's property rights are always at issue every time a ZBA does something. And that's why the procedural concerns are so important. So as we're going through everything we talk about today, the most important fundamental things to remember are to read and follow whatever the applicable statute is, to read and follow your own ordinance and rules. If you're not sure about what you're doing, stop and ask. Don't get rushed into making a bad decision. And always try to be fair and reasonable. If you do all of these things, you may still make a mistake, but you will be doing it in good faith, most likely. And the results are, the repercussions are much lower in that case. Another thing that is very important to remember is where your authority to act comes from. In New Hampshire, all municipal authority for every board official employee comes from the legislature. New Hampshire's constitution gives no authority whatsoever to towns and cities and village districts. All of that authority comes from statutes. So what that means is you have to find a statute that allows you to do what you're looking to do, rather than relying on the fact that there's no statute that says you can't do it. And it also means that you can't have an ordinance or a rule or a procedure that isn't authorized or necessarily implied by a statute. So when you're trying to figure out, can we do this, or how should we be proceeding in this appeal, you have to remember that, first of all, you have to find a statute, and second of all, you have to follow it. You get to make rules of procedure that fill in the gaps in the statutes, but only in a way that is consistent with what the law requires. Another important concept is your relationship to the public. In New Hampshire, I'm going to talk in a minute about procedural due process, but people whose property rights are at stake or personal rights have the right to notice about what's going on and the opportunity to be heard by the board or official who's making that decision. And also, municipalities and all of their boards have a constitutional obligation to assist citizens with the process of government. So what that means is you don't have to tell them how to get something approved or whether it can be approved, but you do have an obligation to tell them how the process works. Here are the applications, here is our zoning ordinance, here are our regulations, here is the timing of when you have to file things. These are all the things you need to file with your application. So you have to tell them how the game works in order for them to be able to play it in a reasonable way. And recently there's been some discussion about how much help you have to give an applicant. And there hasn't been a New Hampshire Supreme Court case, but there have been a few Superior Court decisions and at least one Housing Appeals Board decision where a zoning board or a planning board's unwillingness to work with the applicant during the process to try to find a reasonable compromise that everyone can live with has been significantly criticized. So if you're in a position where an applicant is asking for something specific and you think, yeah, I don't think that that's going to work, but maybe if you changed it slightly and had fewer events per month or 3 fewer parking spaces or something different, during the hearing process with an applicant to suggest ways that they might bring their application, they might amend their application or change their proposal in a way that could be potentially approved. So it's something to think about. And if you're in that situation, we always recommend that you contact your town attorney and talk about it. So as I mentioned, the ZBA is a quasi-judicial board. You collect evidence and hear testimony just like a judge. And from that information, you find facts. You can use your own personal knowledge, but within limits, which we're going to talk about. And then you make a decision based on the facts as you find them, and you apply the proper legal tests to reach a decision on the application. And then you can approve, deny, or modify what's in front of you, and you can impose reasonable conditions on that. The burden of proof is on the applicant to show that they satisfy all of whatever the criteria are for whatever it is they're asking for. And in doing that, you are going to develop a record for possible court or housing appeals board review. And that's going to consist of your minutes and the application and any other communication or documents that get submitted. A couple of important points on this. One is just because no one opposes an application, that doesn't mean that you shouldn't follow all of the same procedural steps and make a thorough reasoned decision that is reflected in your written decision. It doesn't matter whether anyone opposes it. The standards are still supposed to be the same, and the applicant is still supposed to prove to you that they satisfy all of the conditions.
One second, we're reading.
We understand you're still having trouble hearing us. It's echoey in here, and I'm not sure we can do anything about it.
Yeah, I think we did. I mean, I'm still hearing you pretty well, but it is echoey. But we did put in the chat about how people can put on closed captions, which seems to be working as well.
Okay.
And then we also will have a transcription as part of the recording as well.
Okay.
Yeah, we
Great.
apologize for this.
Yes.
It's a newer office. We're supposed to have decent soundproofing
Yes.
acoustically in here, but can I comment quickly on the burden of proof issue?
Yes.
First of all, let me get rid of this chat box. My brain gets scrambled with all the different bubbles and stuff. Hold on. So on the burden of proof issue, I just want to emphasize that this is easily overlooked, I think, with boards. And I think it's so critical. And what we're talking about is that an applicant coming in for an approval, I don't care what they're asking for, they have to give the board evidence that bears on each element. For example, variance is a classic example. They need to give the board, you all, evidence on each element. And coming in with an attorney who simply says, well, you know, this particular use doesn't work, or this isn't right, so therefore we have a hardship. Really isn't going to get in there. And I say that because I'm actually embroiled in a matter right now with what a housing appeals board, in which I'm still waiting for a decision. And it's interesting because this real quick story, the original zoning board had denied this variance, and went to the housing appeals board. We had our hearing, the board reversed the ZBA. I then asked to reconsider, saying that the burden of proof wasn't satisfied, because the attorney literally just made a lot of speculation and conjecture. And the board actually granted my motion in part, and we had another hearing on it. So, and I'm waiting for a decision. So I'm really interested to see what they do with this, because my whole point in that case was that the burden of proof was not satisfied. And we're waiting to hear back whether, you know, an applicant's attorney simply saying this is the case is enough or not. There are Supreme Court cases that would suggest that otherwise, and I'm hoping that the Housing Appeals Board agrees with me, of course. But I just wanted to highlight that, because I think, again, the burden of proof issue sometimes gets overlooked, and it's never you as a board, it's never your burden to prove they're not entitled to something. It's the applicant's burden to prove they are entitled to whatever relief.
Do you see that mute on the side of the thing?
Yes.
See that one?
Covering my finger.
Yeah, I don't know how to do that. We may
Christine?
have uncovered the problem. Yes.
I was wondering if you maybe can move the mic between, this is Alvina. I'm just trying to see if maybe moving the mic closer to each one of you when you talk, maybe that'll help a little bit.
Is this better?
Not really, but Matt is really hard to hear. You are a little better. Matt is really hard to hear. So
Okay.
maybe try whatever you uncovered. Maybe that would be.
Okay, we'll keep at it. We'll keep it moving here.
Yes.
Thank you.
Welcome.
Is there a mute button on that? Okay. We see an extra mute on our TV screen that's not in this system. Okay, is that better?
Can Matt say something?
Something.
No, Matt is still very hard to. So Matt, when you speak, can you move the mic right next to you?
It is right next to me now. Can you hear me?
I can hear you okay, but some people, I guess, still, because there's more of an echo.
Okay. Well, yeah, we've been in this room many times and haven't had this problem, so we'll keep trying.
This has never happened before in this room. Okay, well, we're going to have to keep going. Okay, so when we talk about the process, the New Hampshire Constitution and the U.S. Constitution require similar things. They require procedural due process to protect against the unfair loss of a property right. So those things include notice to people who are affected of what's going to happen, an opportunity to be heard, the ability to appear and speak themselves or through an attorney, a decision made by an impartial tribunal, that's you, a deliberation that you do based on the evidence you've received and the facts that you find from that evidence, a written decision that you give with reasons for what you did, and the ability to appeal your decision to seek any corrections that people might think need to be made. And these on the screen now are the statutes in New Hampshire that require all of those things. So this is where all of these things come from. And here's the important thing. Even if you make a substantively perfect decision, you apply the 5 variance criteria perfectly to the fact, the appeals board is very likely to send it right back to you and make you do it again because of the possibility that you have deprived the applicant or some abutters of their procedural due process rights. So the process is really just as important as the substance, which is why we're doing this morning. You can work with other boards. Sometimes it makes sense for a zoning board and a planning board to hold a joint hearing when a project requires approval from both boards. The thing is that you are going to be applying different standards because each of you are approving different things. So you can have a joint meeting and a joint hearing, and that way everybody only needs to give you their presentation once. And then each board separately will make their decision, deliberating separately and applying their own criteria to the facts. It can be efficient. It doesn't happen very often. I have never had I've never had a set of boards do this, but it's an option that's out there if you're interested.
I was about to ask if you've ever.
I never have. Okay. Usually an applicant only gets one opportunity to apply for a project, the same exact project, which is also why the procedure is important. This is their one shot. So if someone is denied, someone comes in with a project and they are seeking a variance and you deny it, they are not allowed to come back and apply for the same variance for exactly the same project over and over again. They will have to change their project somehow. And the phrase is, it has to be materially different from the first application. And the way courts have interpreted this is that the second application, or the third, or the fourth, in some cases, needs to either the legal standard has changed. So you've changed your ordinance, and now they're coming back for, say, a special exception, but the criteria are different now. Or the application itself is changed in some way that addresses the reasons that it was denied in the first place. And that's not a very high bar. They just have to change it enough so that they're doing something different the second time. It doesn't mean that it has to be good enough to get approved. It just has to be somehow different from the first one. So if noise was the concern the first time, the second time they come back, there needs to be some kind of noise control proposed. It may not be good enough, but if they've proposed it, they get over that first low hurdle and you can hear the application. This the same concept applies to planning boards as well. Okay, and with that, I'm going to turn it over to Matt. And we will.
I have the microphone literally underneath me, and I will even scooch down a little so you can hopefully hear me. I'm going to start here. Let's see, where's our slide? There it is. Okay, now we're in the process. So I'm going to start with the application, where everything kind of starts. Couple points I want to make right off the bat is make sure the applications you have, first of all, make sure you have them for your various forms of relief, special exceptions, equitable waivers, variances, and also make sure that they're up to date. I don't know, I actually still see occasionally a variance application that is using an old standard. And it's been a number of years now since the statute 674:33 is kind of officially our test. And some applications still aren't caught up with that. So definitely double check it. And same with special exceptions, those can obviously change in your zoning as you go year to year. So it's a good idea is to kind of, if during a work session each year or whatnot, just look at your applications and make sure they're up to speed. But now going forward, the point of the application, it literally is the roadmap, how we're going to run the hearing and what the burden of proof is on the applicant and what needs to be presented to you, the board, to decide whether or not they're entitled to relief. As the slide indicates, here it's what facts for each element. What does that person or people need to present to you? The proposal needs to be explained in some detail. You need to understand what you're dealing with, and that can come in different forms depending on the nature of the application. It may be sketches, plans, drawings, usually are assistance. Sometimes there may be other pieces of information that are necessary, whether they're correspondence from professionals, such as real estate experts or whatnot, if we're dealing with variances, for example. So you kind of understand what they want and what they're going to need to present to you, the board, as they go forward. And one thing I want to note here too, and I see this once in a while, and Christine, you maybe have seen it. You deal with a lot of different applicants. Some who are very sophisticated, either on their own or hire counsel to prepare applications. Excuse me. And in fact, some counsel I know bombard you not only with an application, but then give you some additional narrative memorandum that's 20 pages long as to why they should get the relief they want. But then the other side of the coin, you have people who really don't understand much of anything. And they just want to put their new shed 2 feet into the setback, because that's the only place they think they can put it. And they don't really understand what they're asking for or how to do it. So this is my first kind of moment to harken back to something that Christine said earlier, which is the duty to assist. It is a fine line between, writing their application for them and helping them understand what they need to prove to you during a hearing. And I guess what I'm getting at is, sometimes you'll have an application, it's filled out, but it's not really that clear, and it's filled with generalities and things like that. I've had people ask me, can we just deny it because the application is not filled out properly? And I said, I don't think a judge would necessarily appreciate before doing that. I think the better course is to go to the hearing, the applicant gets up, you explain further in detail what you're asking for in the application, and allow them to sort of amend it on the fly in terms of what you need to hear from them, and kind of give them a heads up. This is what we need to understand, for example, on the necessary hardship standard, or public interest and spirit of the ordinance, right? We all know they're a conjoined sort of element now, and there are 2 things you need to know, or one, is it going to change the character of the neighborhood, or is it going to be a danger to public health, safety, or welfare? Most people understand those general questions, but the person might not understand what we're going to do in the application. So all I'm saying is you're going to get a lot of different applications, some with lots of detail, some with a lot less detail. And I think those that are less detail, I just think, go forward at the hearing, try to work with the applicant as best you can, and to get to that end point, because I don't encourage or advise boards to simply reject applications, out of hand for not being specific enough, or having them refile and that kind of thing, or telling them to go get an attorney. A lot of people can't afford an attorney. And quite frankly, a lot of them you don't need an attorney. Of course, land use attorneys are saying that, but don't need them for that kind of stuff. If it's a small issue like an area variance, which we call them, for a shed or something. So you got the application, want to move forward, got to get that hearing scheduled. Well, 676.7 is sort of your go-to statute on this point. 45 days now is when you have to hold your hearing. It used to be 30, so you got that extra 15-day buffer, which actually I found very helpful in a few instances. So you have a little more time in that regard, which is nice. Important point here, if you don't meet the 45-day deadline, let's say you get 47 days or 48 days, you have to hear. No case I'm aware of has yet said that because you didn't get scheduled in time, they automatically get their relief. So I would not, worry about that, but of course, do your very best to you have that hearing within 45 days, and generally speaking, that should never be a problem in that regard. There is a point here about decisions within a particular time, and as I'll talk about, I think I talk about it here later, one of us does. There is actually a time limit now, 90-day time limit on you as a board to make decisions for variances, administrative appeals, etc. So that's important to note, and I'll note that later. But also, many of you have dealt with the dreaded cell towers, and you understand that there's that overlay from federal law, the Telecommunications Act, the TCA, which has what we call a shot clock rule. And I believe, I can't remember now, if it's 120 days or 90 days as well.
Both.
So maybe it's both? Okay.
There's one for a new cell tower, and there's a different one for a modification.
Modification, right, thank you. So you do have time limits there. This is, the point of this exercise is not to get deep into the cell tower realm, thankfully. Council certainly would be able to advise you on. Notices of the hearings, again, same statute. You gotta have your certified mail out 5 days prior to all the parties involved, the butters, and have your newspaper publication. Important point, unlike zoning changes, I've seen this confusion, which is why I bring this up. Unlike zoning changes, the online or website notice is not a substitute for newspaper publication. You still have to do that. I know I've got some boards think, well, I'll just post it on the website and that'll take care of everything, and then don't do newspaper. No, that's not correct. You still need to do that for hearings. And finally, great point, always want to emphasize, err on the side of more notice and not less. As a colleague of ours has said for years, process is cheap, and he's very correct on that. The last thing we want is to be brought to court for a due process violation because notice was not provided. Because guess what? That means it gets remanded. And I don't know too many boards that enjoy getting the cases back after they finally got them off their desk, and all because notice wasn't provided. So try to. Here we go, some changes to 674-33, which is actually what we were just alluding to earlier, and time periods and other fun stuff. So 90 days from the receipt of the application, make a decision. Now that gives you more time than the planning board, which still is a 65-day clock. But nevertheless, 90 days is 90 days. And I know I used to tell ZBAs all the time, hey, this is great, don't rush it, you got plenty of time. Well, 90 days goes by quick. Basically, it's 3 months. So, be aware of that as you're moving forward. Obviously, it can be waived, just like the planning boards, and the time periods can be extended. And I think generally, applicants are willing to work with boards in that regard, especially with some ZBAs. I know in some communities, depending on the time of year, people go away. You have less than a full board. We'll talk about that in a few minutes as well. So, generally, they'll be agreeable to extending it reasonably. And if you don't have enough information to make that final decision, now you can deny it without prejudice and allow them to come back and refile. And earlier, Christina talked about the Fisher v. Dover case, which was, again, not having 2 bites at the same apple. But now the board has that ability, at least, to say, we're not satisfied with what we got. We're not really ready to, we can't approve it, but we're not going to deny it outright either. We're going to give you another chance to come back and give us more. I kind of like that. I'm glad that you've given that opportunity, because sometimes things can change, information can change, things come up you weren't aware of during the course of a hearing, and it may be that someone has to go back to the drawing board and try to figure something out. I mean, we all know that if you have a contentious situation, you'll have abutters involved, along with the applicants. Sometimes, in fact, most of the time, someone will have an attorney or be more than one. And this actually gives you the chance to kind of step aside and sometimes let those folks all kind of figure it out as to what's going to work for them, and then come back to you and maybe find a solution that works for everybody. So that I like it. So remember, you have that now at your disposal, so to speak, when you're making decisions.
And without prejudice is kind of magic language.
Yep.
You need to use those two words in the denial so that there's no question later about whether they can come back.
That's a great point. That is something now that you have in your toolbox, so you definitely want to state that. Don't just say denied.
Those are two different things.
Yeah, denied or denying without prejudice, very different. So make sure you keep that in mind. And also that this time period, the 90-day period, the without prejudice, this applies not just to variances. I think some people see 674:33 and think, oh, that's the variance statute, so it's all variance. No, it's also a special exception. It's anything. It's administrative appeal, equitable, you name it. You have that ability. So take advantage of it if it's going to help in that particular case. Aha, now the right to the full board. I was just kind of intimating about this earlier. I know I have some communities where you have a 5-member ZBA, sometimes no alternates because people don't want to serve for whatever reason. And 2 of those regular members are away for the winter, or maybe one of them, and the other one's sick or something. So you have 3 members available for sometimes more than 1 month, 3 members. And the applicant comes in and it has this quandary. Well, do I go forward with 3 members, or do I see if I can get 5? As we know, you need 3 members to vote in favor of a particular, whatever vote you're casting. So it's to the applicant's advantage, certainly to have more available. So, our position has always been, and there's no case on this specifically, but our position has always been that you offer the applicant a chance to continue the case. Again, this whole 90-day clock thing, we got to remember that's out there. So that should be on the record that, we're going to continue this. The other side would like a 5-member board, or maybe even at least 4 members. We will reschedule it for the next month. That the applicant understands that the 90-day clock is running, and that they're asking for this. So I would definitely put the onus on the applicant that this is their request, and that this could necessarily impact that 90-day period, which might have to be revisited, but certainly give them the option. I do not recommend, nor does Christine recommend, that you sort of force someone to proceed out of the box with less than 5-member board.
Yeah.
If we go forward, they come back, and you just can't seem to get 5 members, but you've got 4. I think at some point you do move forward, and you can deny that request. But certainly out of the box, if that's where we're starting, give that applicant the opportunity until we get someone else. And a few more questions here about substitution and people deciding cases who weren't there originally, etc. I've seen this many times. Sometimes we just got through some. Well, actually, we're still in town meeting cycle technically. I got a couple in May actually, but generally speaking, we're through town meeting. We had elections for those with elected boards, and you have some members who were on the board at the beginning of this thing, and then new members jumped on, after the elections in the same manner. Can they participate? Yes, they can. I think it's important here, though, and again, we're always thinking with our lawyer, obviously, hats on in litigation in court. So I'm thinking, make sure that record's clear. If you're going to have Joe Smith come in and sit on a case that he wasn't present for or involved with previously for whatever reason, it needs to be clear on the record that Mr. Smith has reviewed the prior materials, that he is as up to speed as he can be, and has a general understanding of the matter, that he can proceed and give it due consideration if it's due. So yes, substitution is okay with someone, but again, I would make it very clear in the record that that person is ready to go. And I say that because I have seen now more and more the court, both Superior and Supreme, kind of digging into each individual member's understanding of a matter when they're discussing it and voting on it. And, when I think both of us, Christine and I, were kind of starting out, the idea in the law was much more the board acts as an entity. We don't really look at each individual subjective understanding of a member. We look at the vote, we look at the evidence, and we say whether that was reasonable or not. Well, it seems to be getting taking a left turn on that in that way. And I've seen boards, I've seen courts, the Housing Board of Appeals as well, actually. That was a big one I had, where the other lawyer cleverly went after a couple of members who, had some trouble understanding a few things. And the board noted that in their order. One of the reasons they reversed it said, we don't think these people understood what they were doing. So that's why I keep emphasizing the record. That's in the minutes, and make sure the minutes reflect that the member who is who's coming in off the bench, so to speak, is ready to go and familiar with the case. As for the hearing itself, first rule, make sure you follow your rules of procedure. You should have them. I hope all of you out there who can hear this have rules of procedure governing your zoning board. You should follow this in terms of your course of action for a hearing. That means after an introduction, applicant can go first, then abutters, perhaps those in favor, those opposed, then perhaps other members of the public. Then there's a rebuttal. I always encourage a rebuttal to be allowed the applicant at the end to sum up and respond to anything that was said. And then, of course, go from there. You can and emphasize should, and that should have 5 exclamation points, should ask questions, parties. Don't be shy. This is your moment to gather information. And sometimes, again, getting back to that duty to assist idea, some people don't know what they don't know. So you need to be the ones to sort of ask those questions, to dig down deeper to understand what's going to happen, how this is going to work, whatever it is they're asking for, how that's going to fit into the criteria that you're applying. Please, go ahead.
Yes, I'll give you a specific example. A ZBA that I was working with had an applicant who did not understand the unreasonable hardship issue for a variance. And I coached that ZBA through that application. And one of the things I said was, this person does not understand the standard. And you have an obligation to at least walk them through the standard. So ask them questions like, can you tell me something, some special condition of this property that makes it different from other properties in the area? That is a specific part of the standard that hopefully you all will understand after you hear Chris talk, and hopefully you'll be able to hear him better than you can hear us. So if you ask those kinds of questions, you can pull out the information that you need. And but if you don't do that, there is a danger that a judge is going to say, you didn't give this applicant a fair shot at it. You didn't find that there was a special condition of the property because you never asked that question. So you don't have to tell them how to get it approved. You don't have to tell them what the special condition is, but I would always advise that you ask them those kinds of questions because you may be in a better position to understand the standard than they are.
Excellent point, thank you. And I'm looking at the clock. I understand it's almost 9:40, so I'm going to try to keep moving and not blab on too much. A couple highlights from this slide then. Alternates, again, if they're not sitting in, can they participate in the hearing and ask questions? Yes, but make sure your procedural rules allow for that. Disqualified members. If you're recused from a matter, you still have rights. You're still a member of the public. So if you're not on the board, you can go out in the gallery, you can speak to an application. Obviously, if you're the applicant, that's a different story. But if you are someone who's against or in favor of something and you're recused, you have every right to speak on that matter, just like anyone else does who's in the public. And finally, as it says here, you can hear all parties, but you can hear such other persons as deem appropriate, meaning people who, for example, just general members of the public who don't live maybe anywhere near this project, or perhaps someone who's from an organization outside the community. I always say the chair runs the meeting. I think the chair can use that fairly judiciously and make decisions as to, how long each person has to talk. Obviously, if it's a contentious case, you may have to put a time limit on each person speaking, or else you'll be there for hours and hours. You can limit repeat comments and make sure everyone has a chance once before someone else talks again, that kind of thing. So don't forget about that. And the chair does have that authority to run that meeting fluidly. Continuing to another day, that's fine. Again, remember the 90 days, but you can continue. And again, no additional mail notice, certified letters, that's not needed as long as you announce time, date, place at the end of that session. Because you're already in a hearing. The hearing just continues. So as long as it's clear, you're good. Can't emphasize this enough. No contact between parties and board members in interim days. Try to please avoid all of those discussions. If the applicant has a question, you can have, maybe it's your secretary administrator or a planner. I know like in one town, we have a planning administrator who sort of serves for both boards and helps facilitate, the schedules and things. That's fine, but the board members should not be communicating with folks. And finally, don't close the hearings too soon. Never ever, I'll probably repeat this in another slide, I'm sure. Never hesitate, if you can, to wait and come back the next month or 2 weeks, whatever your next hearing would be. If you have questions for your legal counsel, do not hesitate to stop and make sure you understand what you're doing before you vote. Again, I understand 90 days. I know it's out there, but if you make that case, and say you're getting close to 90 and you say, this is a very difficult matter, we really feel we need guidance from our counsel, so we need to go beyond the 90 days for maybe one cycle. I find it very hard to believe an applicant would reject that, and if they did, I think the judge would be on your side. So I'm always going to say, don't hesitate to wait, as long as it's reasonable, to delay your decision. You need more information from your counsel. And one other thing I want to mention real fast is reopening hearings. If it gets to the point you close it too soon, and all of a sudden someone shows up with more information, whether it's new photographs or a new study or something like that, and during the kind of deliberative session and include that as the evidence. So we're going to reopen that hearing, which may mean you got to remail or mail out new notices, most likely because you're already closed the hearing. Obtaining legal advice, just touched on this. You have the right, 91A, there's a couple options. There's the non-meeting with counsel, which literally is you're not, there's no minutes, there's no notice, nothing. You just meet with the attorney on the phone or in person to discuss a matter. The legal issues of the matter. Do not deliberate during that period. If I'm in your room with you, I'm going to tell you, and some of you maybe have heard me say this, I don't want to talk about this decision. We're going to talk about the issues, the law, what the cases say, what statutes say, but we're not going to actually sit there and go around the table and start saying what people feel about particular elements of a particular application. If you want to review advice, if Christine or I were to send a board a letter or email explaining a particular statute or some case law bearing on the topic, you may consider that amongst yourselves a non-public session. But again, non-public session, not a non-meeting. So you still have to have the hallmarks of the session, the notice, and then the roll call vote to go in, and the reason for going in, which we've given you here, is 91A3 Roman 2 F and L, small L, another one, to allow you to go in and talk to discuss comments from your counsel. That's okay. Okay, deliberating. So when you do it, well, you close your hearing first, and make sure you do that. I've had some boards that don't remember to close the hearing and just start deliberating. And again, you get some people in the audience who catch that, and they're going to get up and want to keep talking, and they can't because you haven't closed it yet. So
magic words. Say the words. I'm closing the hearing.
Seriously, yeah. I mean, if you vote to close it, it's closed, and then the board is now entering deliberative session. And again, that always has to be in public. Third bullet. Do not do any of this behind closed doors. Some boards on occasion have done that, and the courts will always throw it out and send it back. So it's it's a public meeting. It's not a hearing, so you don't need to give personal notice to everybody. The whole certified letters to everybody. You don't have to do all that. It's a general posted like a normal meeting if that's what you're going to be doing. And as far as, I'm not sure if we have this in the next slide or not. Yes. Only among the board members. No comments from parties or public. And then generally, 99.99999% of the time, the board should not ask any questions during deliberation. I say that percentage because it is the very, very, very tiny moment off and on when there's something, just some really, might seem totally innocuous, but some little question that the board has that could make everything change, depending on what the answer is. Because they just didn't hear it right or they didn't understand it. I have normally said there's a little bit of play there in the joints, I think, to do that. You're not opening it up for more information, you're just clarifying something. I still don't like it. I still don't encourage boards to do it, but if it means, look, we can't, unless I know the answer to this particular thing, I can't do anything with this. I don't go forward, or then I might allow it. But if it's very minor, very narrow, and just clarifying something that's already been said, that would be okay. But again, generally, don't do it. And minutes should reflect, frankly, should reflect all the information, the testimony of the hearing, accurately and in significant detail. I don't say you need to have verbatim minutes. Very few communities can do that, but please make sure they are detailed enough that, you know, if Christy and I have to take something to court, that's what we rely upon. That's what the judge is relying upon. And they're going to look at the information that was actually presented to you outside of documents. And sometimes you have cases where there's a lot of testimony, whether it's butters testifying to issues that they've experienced next to a particular property that's before you, or it's in terms of how a property has been used, or representations that are being made by an applicant as to what he or she or it is going to do with the property. That's important. So make sure it's all there, and in the deliberations as well. Obviously, make sure that's detailed. And just as a side note, kind of practice pointer, I've seen a few towns starting to do this, which I really appreciate, with variances in particular, is they will actually in the minutes put sort of a title, like for each, above each paragraph, like for example, public interest, and they'll write in, you know, public interest, and then they'll have like the discussion, and then unnecessary hardship, and they'll have the discussion. I find that very helpful. It helps orient me to where, if I know what issues are before the court when we're there, I know where to look, and I know where to bring the judge. And that's even better when the judge can see that everybody's debating on topics. Now, you don't all have to talk at length on every element, but we definitely want to see discussion among the members and throughout all of this. And the more organized it is, the easier it is for us when we go to court. And finally, yeah, look at the relief that's sought, go over those standards, and make sure, again, as we talked before, make sure that they are clear on what you're looking for, and understand when you're deliberating, discussing how that evidence fits in with those standards. Again, I go back to public interest. Again, kind of a classic of, is this going to disrupt or be out of character with the neighborhood, with the general area? Yes or no? And you can look at that and talk about that. Is there going to be a danger to public health, safety, welfare? Are there going to be stormwater or some sort of drainage concerns? Are there going to be, I want to say traffic, occasionally see a traffic issue come up. I know most people, that's planning, you can't go in front of them. Well, no, you can still consider traffic, consider whatever you want. But obviously, a lot of times that will be seen in the planning board process if we're dealing with something that requires a site plan. But understanding where all those things fit in, because the more sort of on top of it you are as board members, the court will have that much more confidence in your decisions. And frankly, and I can say this with experience, and I've done this long enough, that you have some communities that, you know, go in front of the court off and on for an application, or, you know, for a particular cases, whether it's ZBA, planning board. I had a planning board once that just had, I guess, a run where for the 3 or 4 years, we kind of go in front of the court with some appeals, and the judge got to know the board. And frankly, that board, this was many, many years ago, but the board didn't have great minutes. The judge got frustrated. So when I come back with that town, the judge kind of, you know, she didn't roll her eyes, but I could tell she's like, okay, I've already got my work cut out for me, because that judge is already suspect that the minutes aren't going to be good, that she's not going to understand what's going on. And that just makes the job hard for everyone. So again, understanding where you're at, understanding how everything fits in, and making that clear and concise in your deliberation goes a long way. Findings of fact, another new item that we have in 676.3.1. It used to be denials had to include written reasons for the denial. Now all written decisions, underscore, all cap, bold, all. That means granting something, denying something, I guess denying without prejudice as well. Maybe. I don't
I'm
know.
not sure on denying without prejudice. I think what you could say is we don't have enough information to make findings of fact. And that's why we're denying without prejudice.
Or if those are the findings are, that's the problem. But I don't know, but that's an interesting one. But in any event, let's keep it simple. If you grant something now, you need to explain the findings of fact that support that decision. And it says here, if you don't give specific findings supporting a disapproval, that's grounds for automatic reversal and remand by Superior Court, excuse me, or Housing Board of Appeals. I think it would it cover both. You've got to remember that's sort of out there as well with all of this. Whenever we mention the court, you got to think of the board as well. If there are other factors, however, that support it, then that'd be another reason to reverse it, and it wouldn't go back to you on a remand. And finally, on that, minutes will not be enough anymore. It used to be, if your minutes were detailed, you can kind of point to that and go, well, the findings are really in the minutes. It's all there. And there were a couple of old cases that suggested that was sufficient, but now legislatively, that is no longer the case. So make sure those findings are there. And again, see your counsel if you need to on that for guidance. I've had some boards do that already, and they've, I think it's really helped. And decisions have been better for it, I think, when we look at court. Finally, for me, expert evidence, something we see off and on in these cases. Again, more of the complex ones, not the more simple shed 2 feet into the setback. But real quick on experts, you're like a judge, like Christine said, quasi-judicial capacity. You can hear from experts, you can weigh opinions, you can accept or reject opinions. But if you're going to do that, you got to have reasons. And those reasons have to have some grounds, not just I don't like that or I don't agree just because I don't agree, it doesn't sit with me. You got to have a little more reason than that to contradict that expert opinion. Studies and articles you may pull up from the web, again, are not going to do it, nor will your general opinions based on your understanding and knowledge of an area. That is evidence, and you've probably heard all this, most of you who've been on the board know this, gospel, that you can use your experiences and understanding of an area as evidence. But when you're faced with an expert, that's different. That's a higher hurdle. So while what you have in front of you and what your experiences are can be considered, if an expert says otherwise, generally the expert is probably going to win out on that. If you try to reject that opinion just on that basis alone. And I know that finally you're going to ask, well, what do we do then? How do we compete with that? One way is through abutters who might be bringing in their own information and experts, and some do. In some towns, I know there are cities when these things get really hot. You'll have lawyers on both sides who get up there and get, whether it's appraisals or wetland scientists or whatever you're dealing with, who compete and give you conflicting opinions. And you can also get your own opinions, third party. If you have trouble with something and you're not sure and you want something peer reviewed or whatnot, you can do that and you have the right to charge for that. Again, you got to have a really good reason to do it. You can't just do it on a whim, but you can. And I think that, of course, will go a long way considering that expert testimony that the applicant has. So with that, I'm going to pass it back to Christine.
Okay, so motions. If you have rules of procedure that dictate how you make motions and second them and take votes, follow your rules of procedure. If you don't, remember that the law requires that your minutes include the names of the people who made and seconded every motion. Someone can come to the meeting where you are deliberating with a draft motion ahead of time. Because remember, now you are deliberating, which is the point at which you're allowed to start thinking about how you're going to decide. If a motion is drafted ahead of time, do not circulate it to anyone. Bring it to the meeting and then make the motion, read it to the board, then you can circulate copies and the board can discuss it. I have worked with board chairs or one person who's assigned to work with me to draft motions ahead of time. Sometimes we draft them going in both directions because nobody knows how the board is going to go. The key is anything that's drafted ahead of time does not get circulated to anyone until you are actually in the meeting and deliberating. And just like at town meeting, one motion at a time. Somebody makes a motion and then someone says, well, I want to make a different motion. The chair should say, no, we're on Bob's motion. And we're going to discuss Bob's motion, and unless he withdraws it, we're going to vote on it. Motion can be amended, that's fine. But one motion at a time. When you're drafting a motion, you want to start obviously with what is the applicant asking you for. But if you feel that you need to put conditions on it or approve something that is slightly different, they're asking you for a 12-foot variance and you think 11 is the most that you can justify, you can grant an 11-foot variance. You have to include all of your conditions. This is where you might need to discuss your motion, amend the motion, all of that. And the text of the motion and the person who made and seconded it should show up in your minutes. What happens to that motion during the discussion and deliberations and vote should also be in your minutes. If you have a written copy of your motion, give it to the person who is taking the minutes. And I really strongly suggest that your motion include the findings of fact somehow. And making yourself go through this exercise can help you remember that you're supposed to have findings of fact. I find, my motion is that this the applicant satisfies the property, no diminution in property values for a variance because we received a letter from a realtor, blah, 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 or something like that. Conditions of approval, there are two kinds. Conditions precedent are things that have to be fulfilled before any plan gets signed and recorded and before the applicant can start on the project. You have to get a wetlands permit from DES. You have to submit a revised plan to us that shows these 5 things, stuff like that. Conditions subsequent are conditions that continue to attach to the use of the property going forward. You can have 27 events per year. You can operate Monday through Friday, these hours, stuff like that. So all of those conditions need to be voted on, part of a motion approved by the board, and they need to show up in your written decision. One thing you are not allowed to do is attach a condition that says you can use your property this way as long as you own it. Condition variances, special exceptions, all of that run with the land. In general, it doesn't matter if the property is sold, if someone else takes over the business, it doesn't matter. There are 2 very narrow exceptions for people with disabilities who need modifications to allow them to use the property. The law says you can limit those to the amount of time that that person needs to regularly use the property. And there's another exception for agricultural uses, for as long as that part of the use is being actively used. But otherwise, they run with the land. Voting on motions. Anything that a ZBA does requires at least 3 yes votes on a motion. Anything. You want to grant something, you want to deny something, anything you're doing, regardless of how many people are sitting. So that gets back to the right to a full board that Matt talked about earlier. If you have 3 members sitting on a case, all 3 of them have to vote yes on a motion for anything to happen. Your rules of procedure should explain what happens when a motion fails. If you don't get 3 votes in favor of a motion, does that mean your application is denied? Or does that mean you haven't made a decision? Same thing with if you have 4 members sitting and you have a tie. There are different theories about that and how that should work. But what's easiest is if your rules of procedure explain how that works for you, and then you follow that. On variances, there are two schools of thought about this. One is that the board will vote, take a separate vote on each of the 5 variance criteria. The other school of thought is you take one up-down vote, and that's it. Some people think that one way is better, because it's possible that no one on the board will think that the applicant has met all 5 criteria, but everybody thinks that they met at least one of them, and you all think they failed a different one. So, but that would still be a yes vote if you're, or it would still be a no vote if it's just one up-down vote. If you're voting on each criterion separately, each of those would come out yes, and they would get an approval. So I'm not sure there's one right way. What the law requires is that you pick one and you stick with it. So again, your rules of procedure should explain how you're going to do this, and then you have to follow that method. You can vote to change your method, but the new method will not take effect until 60 days have passed, and it won't affect any case that was pending before you at the time you voted to change your method. So there are some limits on how you should do it. So I guess the homework here is to check and see how you do it. Do your rules of procedure actually address that? And if they don't, they probably should. But one additional thing on this point though, because now you have to have findings of fact in your written decision about why the application is being approved or denied. So that kind of indicates that you need to have a discussion about the findings of fact for each criterion for variances or each factor for a special exception. So that might affect how you want to vote on things. Your written notice of decision. Every decision you make requires a written notice. And it will guide how the property gets used. Remember that you are not drafting the written decision just for the people who are in the room. It is important that you include everything in the written decision that you want to attach to this property going forward. So that later on, in 5 years or 10 years, when none of you are on the board anymore, perhaps, and you have a new building code enforcement officer, you have a new board of selectmen, everybody needs to know what was approved. So all of that should go into your decision. And in an appeal, the judge is going to look at your written decision to see, does it include all the things that it should? It should include the motion that was passed. If it's a denial, you must include the reasons it was denied. It has to include all of the conditions that you're putting on this approval and explain them in a way that people who are not in the room can understand them. It has to include findings of fact that you make, which support each factor of your decision. And then you want to include any deadlines or milestones that have to be achieved over time. If you are a community that has its approvals expire within a certain, if they are not exercised within a certain amount of time, that should also be there. The written decision and the meeting minutes have to be publicly available within 5 business days after the vote. If you miss that deadline, that first of all, it's a violation of the right to know law because your minutes are supposed to be available within 5 business days. And second, it doesn't extend the deadline for someone to appeal, but it does give them extra time to amend their appeal if they want to. And most importantly, you need to make the written decision and the minutes available to the applicant within 5 business days after you vote. The law does not say how you do that. So you can email them, you can give them a call or send them an email and say, it's here in the office to pick it up. You can send it by US mail, whatever method you use, pick one, put it in your rules of procedure and stick to it so everybody understands what you're going to be doing. And if you're going to give the applicant the option of telling you how they want their notice, put that in your rules of procedure so that everybody knows. And I'm going to turn it back over to Matt to finish up.
Okay, lightning round, we got the 9 minutes. Real quick, just before I forget, contrary to some people's belief, notices of decision don't have to be published. I think so, or posted. I think some people think, well, I got to post my decision. No, you don't. No, you got to get it out to the right parties, make sure they have it within the requisite days. You don't have to post it.
You can't.
You can,
But you don't have
yeah, sure. If you wanted that, it's no problem. You don't have to. Okay, motions for a hearing. As you probably know, most of you, that is the kind of interim step that a dissatisfied person needs to take before going to court or housing board of appeals with an appeal of your decision. Has to be filed within 30 days of the decision. Generally, it is obviously the applicant, someone directly affected, which is normally in a butter. Sometimes someone who's not a butter, but usually in a butter. In the governing body, they also have statutory right to appeal. I know I've been retained occasionally by a governing body of the community to challenge a ZBA decision because they have that statutory right. Even without a motion, and this is not a new case anymore, I suppose. Wow, that's back in 07. More recent. You have the right on your own to revisit a decision within that 30-day period if you think there was a mistake. And occasionally that's happened. A member might say, hey, I voted on this. I went back and looked at the record that I think I made a mistake, and I really want to go back and do this. You got to notice it, make sure people know you're going to do it. And, it's a public meeting. You don't do it privately, but you have the right to do that. And if you are going to, if someone does file a motion with you for rehearing, they need to set forth each reason why your original decision was, as they say, unlawful or unreasonable. That's the legal standard. And the important point to remember with this is that if they don't raise something, they can't bring it up later in a court. So if you denied a variance and you gave 4 reasons for it, they didn't meet 4 of the elements and they only go after 3 of them, that 4th one's gone. They can't bring that up later in court. As for the motion itself, it is a 30-day turnaround to grant or deny. Public meeting, emphasize again, I'm bold for a reason. Meeting, don't have to have, you can have a hearing, but you don't have to, and normally, I know we would advise you not to. You're basically looking to see whether the decision you made originally has some mistake of fact or in your interpretation of whatever law applies. That's what you're looking at. You don't want to, new findings, new reasons, don't go there. I'm the unfortunate owner of a case called McDonald versus Effingham that came out now many years ago, where the town of Effingham ZBA decided on a motion for rehearing to deny it and added new reasons to deny it. And originally we had tried to argue that applicant had to file yet another motion for rehearing, and the court said no. You make a decision up or down on a rehearing, but you don't add new reasons. If you want to add new reasons, then you have a new hearing. Grant it, and then deny it again, but you don't just do that through a motion for rehearing.
So this is an exception to the findings of fact thing that we've just been hammering on. Making a decision on a motion for rehearing does not require findings of fact. All you're doing is saying, yes, we will rehear it, or no, we won't rehear it. So that's the exception.
Yep. As far as new evidence submitted with a motion, again, my rule of thumb is if it's information that someone could have presented to the board originally and didn't do it for whatever reason, that is not sufficient grounds to grant a rehearing. Normally, a judge would not grant a reconsideration if I'm in a civil context for that reason. If something is new that could not be presented because people weren't aware of it, or it became, at the last minute, someone discovered it after the fact, that could be grounds to do it, and it might be worth revisiting. And if you do grant the rehearing, and I think that might be on next slide. Yep, the case begins again. Literally, it's a do-over. You are not limited by issues. You are not limited by arguments that were made before. It is a new hearing, new notice, the whole thing. You're doing it again. Now, with that said, I highly recommend that you incorporate into the record the prior documents, discussions, whatever were made before. You can bring that in as part of your record so it's there to the extent it's relevant and necessary, because you don't need to reinvent the whole wheel. But the idea, though, is that in terms of people making arguments, testifying, etc., they can say what they need to say, and you ask the questions. You're not foreclosed from, for example, limiting it to only what's referred to in that motion. That simply gets them out in the door for that hearing. And then go forward accordingly, have your hearing, and you're going to follow all the same processes that we just talked about earlier regarding through the hearing process, deliberation, decision, findings of fact, all that happens. It's a do-over. Okay, so after you do your hearing, let's say you just deny it outright, then that applicant has 30 days to appeal the decision. They're either going to go to Superior Court or the Housing Appeals Board. Just personal experience, I am seeing still a fair amount of Housing Appeals Board challenges. I think one of the reasons for that is the efficiency of the board, generally speaking. I believe the statute and the statute provided for you is RSA Chapter 679, it's a general statute chapter. 90 days from filing the appeal to when you get a hearing, and then it's supposed to be a 60-day turnaround to get the decision.
Yeah.
That's probably a little quicker than most Superior Court cases take this day and age. So, a little faster. And, you can ask people, from the political side of things, whether they think they have a better shot there because of the makeup of the board or whatever. And that would be a reason we see more of that as well. But that's out there, and that comes up more and more, I think. And as we said before, governing bodies allowed to appeal a decision, not just file a motion for rehearing, but can also challenge it through appeal. And as far as the record goes, next slide is certified record. Here we are. This is kind of the key for all of us as we go into court on this thing. You're gonna hear from your counsel asking for the record of the case, and that's going to be the soup to nuts, literally everything that came into that matter, no matter how insignificant. And that's again the application, the correspondence, any reports, photos, letters, emails, all emails, absolutely. And even if there are emails between the applicant may have sent to the town about the case or any of those things, anything that really involves this matter, we want it. And then we'll go through, and then your counsel will let you know what should and shouldn't be in the record. But I always err on the side of caution and put everything in that record. In fact, I usually ask people for a copy of the tax map and the tax card as well for the property. Just so, it's background information. I never get any heat from the other side on that. And that gives the judge, orients the judge to the property, where it is, and some of the specifics about that property. So very important though, to get the record assembled as quick as you can once you're asked, because there's a timeline to do that. And as we know, some of these records can be a little voluminous. So it takes time. And finally, the more that you on your end can kind of organize the records and the documents and put them together, the less it's going to cost us and our staff to go through it and try to sort it all out and put it all together. So if you just send us a stack of documents and just say, here's the whole record with an elastic around it, but nothing's been collated or organized, we're going to have to go through all that and put it together in some coherent way for the judge to take it in and review it.
Yeah.
So again, believe it or not, and you've heard it here first, we're trying to save you money. So
put it in chronological order.
Yeah.
Attach everything that goes together.
Yeah.
It'll cost you so much less.
It will, and it'll help us in court. Finally, the last slide, just concluding suggestions here, and I don't know if you have anything you want to say, Christine. I don't want to.
I want to apologize sincerely for the audio problems, and we are going to fix it for the Q&A after lunch. But my concluding suggestions are try to be fair and reasonable, learn as much as you can, and ask for help when you need it.
Yep, I echo all of that. And finally, I like that second bullet, very important. Stay up to date on those changes, because we do see them more often than not these days, little ones, if not big ones. So stay up to date and keep in touch with your counsel about that as well. And make sure your legal counsel has an up-to-date copy of your zoning ordinance and possibly rules of procedure as well.
Yes, very helpful.
Very helpful. And with that, I guess we'll hopefully see or hear from folks at 12:30. 12:45.
Yes. Thank you, Jennifer.
All right. Thank you, Christine and Matt. I think we just had one more. I just took back control. Your contact information. Again, we have the slides up on our website. So we are going to hold off on the Q&A until 12:45 after lunch, when we have a whole session dedicated to questions. I've been tracking all of the questions that have come in during the session. I think we are up to 8 questions right now. So we will be moving those forward to that 12:45 session. So we thank you for participating. Again, we apologize for the audio. We will get that corrected for the next one. And we appreciate your feedback, and thank you for joining us. And we will be now on a 15-minute break, and we will see you back at 10:30. Thank you again.